how long it takes to leave.
You're still using it.
No,
No, because you want. Okay, I'm gonna tell you what. If you're telling me you're not, I'm gonna take you back. I'll call over, get levels, and then we'll see exactly what's happening.
so I got
You want me to do that?
so I can drop to you.
No.
I'm sorry, I
You
didn't.
would go back there with my bailiff. I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay. And this must be some super duper cocaine.
I have
So we'll figure it out. And so what I'm going to do is, Sir Allen, you can take him back. We will call over to community corrections, get your levels, and then we'll figure out what's happening. Court does call the case. People versus Romeo Serva. Oh, 2 in a row.
And with addition, we have of Mr. Serva, who is filtering.
Your name, sir?
Romeo Serva.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond.
Probable cause conference will be adjourned to May 29th, 2025. 9 a.m. Need a green sheet and then
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Serva is 20 years old. He has 2 children that he takes sole custody of. He has to take care of them right now. They're in the care of his father and his foster grandfather and foster grandmother, who aren't able to actually keep taking care of his children. He has been in school. He has a 4.0 GPA. He just got his transcript back. He had a job interview. He's doing really well. The reason he was missing them is just he had so many things going on. They were early in the morning. He has these 2 kids. I can assure you that if you put him on a tether, Your Honor, that you will be seeing obviously no missed tests, but no positives or anything like that. He's not drinking. He doesn't drink. He reacts very poorly to it. So we are going to be asking for that.
Yeah, but he wasn't testing on his SilverLink device. I mean, he just wasn't testing like he should.
Yeah, there's 2 that he missed. He was in custody for those. Those are the first 2 missed ones on the report from March. And then he had 4 missed ones, but he submitted a compliant test like within 15 minutes.
I'm talking about, I got that, but his April 24th report from community correction.
I'm not in the seat of that. The last one I have is as of April 24th. I may have missed it.
April.
The report that I have, the last test on there that was missed was the 23rd.
Right. Do you have, there should be a bond violation report from April 20, dated April 24th, 2020.
Oh, this is the one. Oh, no, sorry. Yeah, April 24th. This is the same one I'm looking at.
Okay. Go ahead.
Again, as 2 of those were missed, 1 he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after the 9 a.m. block. I believe there's only 2 that he missed he never retested for, and those were the newly added time window. I believe he had either forgotten about those, and I understand that that's not an excuse. He just has a lot going on with school, with work, with his 2 kids, and that's why I believe having him on a tether would resolve this issue. He should have been put on tether from the beginning, honestly. But if Your Honor releases him on that tether, he's not missing any of his drug tests. So.
In your response,
Your Honor, he is undergoing mitigation for mental health concerns that we're going to provide to the prosecution. I've talked to his attorney in his Oakland County cases. He is on probation for those. He's testing in so many different places, so many different things. That's why also he is having trouble keeping track of these tests. And again, I believe that tether would help it all. Huh? What do you think?
When I heard
He's saying that he requested, well, he wanted a tether in the first place, and
You're saying a tether. You're talking a scram tether?
yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't kill me. I don't drink alcohol. There's no alcohol in my household. There's just 2 children, and I go to school every day.
2 children and some pot, right?
Well, I smoke outside the house.
Here we go again, another day in court, and the docket is packed. From competency reviews to cocaine tests, every case tells a story of choices and consequences.
And it's never around them.
Do you have a card?
Yeah, I do, and I
Give us your card.
offer to give that to community corrections, but they refuse to take it every time I offer it to them.
and his father submitted it. They'd already submitted it to community corrections. I don't know why community corrections lost track of it, but I talked to his father yesterday, and his father said that he sent community corrections a copy of it again yesterday. But that every time he goes to test, he has his medical marijuana card on him with active, and I can send that to him right now.
He will modify his bond, although he may not be entitled to a $25,000 personal reconnaissance bond, but he got a scram tether card.
Thank you, Your Honor.
And I've sent this over for 20 hours.
Thank you, Your Honor.
Thank you.
Thank you.
Court does recall the case, People versus Hill. Well,
Yes, Your Honor, we did receive the results from this matter, and I have discussed them with my client. And what the likely outcome will be based on that result.
Pardon?
And what the likely outcome will be based on that result.
Well, just so the record is clear, he had indicated during the hearing hadn't been using, but levels started out of cocaine started out on May 7th at 424, and went down by May 9th to 353, but then by the 14th shot up to 889. Sorry, anything else you want to say?
Your Honor, my client is just asking for a 1-week adjournment in this case. We're going to have him screened for drug court, if that's suitable, a good fit for him.
Our conference will be adjourned May 29th in 2 weeks.
2 weeks. Thank you, Your Honor.
Absolutely. 2025, 9 a.m. is bond is revoked.
And Mr. Hill?
People versus Sherry Hughes.
People. Or you want you.
Hughes, not you.
Judge, I did submit a green form. I did receive a call from Miss Hughes' mom yesterday stating that she was at St. Joe's ER, psych ER. I got a call around 8:30 saying that they're waiting to be discharged. And I don't think she's in a position to actually be still going to court today. It's the court to excuse her presence and adjourn this matter.
Well, I'll need some documents.
Whoa, this judge wastes no time. Notice how quickly the conversation shifts from bond violation to drug use accountability. The courtroom tension spikes when the defendant admits, probably not testing clean.
Mr. Ready, but I'll return this over to 22nd, 1 week out.
Thank you, Judge. I will.
2025, 9 a.m.
Thank you. I will provide the discharge paperwork when I get it. Thank you.
Court calls the case of the People versus says live. So Don Skinner. I want to hear that.
We're ready, Ms. Mariana. Lauren Brown, Deputy Chief Public Defender, from Digging on behalf of Mr. Skinner, approaches the podium. Well, please state your name.
LaDante Skinner.
Your Honor, today is the date and time set for the probable cause conference. Respectfully requesting this matter be set for preliminary on the program Yes.
Discovery is place.
Yes, to the best of our knowledge, discovery is.
We'll have the witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That will be before judge.
Your Honor, what does the court show us?
1,000 cash surety on the case ending in 5724. And on the other matter, same thing.
10%? Over 10%, Your Honor.
Hmm?
Over 10% allowed.
It is cash surety 10%.
Okay. Thank you very much.
Courthouse case People versus Joel Stevens.
On behalf of Mr. Joel Stevens. Who is approaching?
Joel Simmons.
Morning.
Your Honor, we are going to be setting this for a preliminary examination.
Discovery is complete. People have their witnesses available the 27th. Preliminary examination, May 27th, 2025. 9 a.m. That's before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Davian Thomas.
We're ready on that, Your Honor. On Brown, yes, the Chief Public. They're living on behalf of Mr. Thomas. Mr. Thomas, would you state your name for the record?
Davian Thomas.
We're doing the plea.
Yes.
The plea form indicates the defendant will be pleading guilty to an added count 3 of larceny by false pretense of 200 to 1,000 to 1 year offense. On his successful plea to that charge, counts 1 and 2 would be dismissed. It is okay for him to stay. That's it.
That is our understanding, Your Honor.
You have him sworn.
Raise your right hand. Do you solemnly swear in front of the testimony about the truth, the whole truth, and nothing but the truth, so help you?
Yes.
What's your name?
Davian Thomas, Your Honor.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny by false pretenses, $200 to 1,000. It is a misdemeanor punishable act to 1 year incarceration at $2,000 fine plus court costs. The fine could be increased 3 times the value of the property, 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that becomes maximum fine. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You said before Judge Brown in the 1418 court. Do you understand?
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes.
Yes. And to that charge, how do you plead?
Guilty, Your Honor.
You understand the plea? Not have a trial?
Yes, Your Honor.
Do you sign an advice of rights form?
Yes, Your Honor.
All right, Coach. Sign an advice of rights form. Do you have any questions regarding those rights?
No, Your Honor.
You see a copy on the podium. Please look at paragraph 5. Those are your rights that are part of a trial. You understand that pleading guilty and giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily,
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you will be guilty of these offenses?
Yes, Your
On between the dates of January 27, 2024 and January 31st, 2024, at the location of Eastern Eateries on the Union campus, Eastern Michigan, Washington County, state of Michigan, what did you do that makes you think that
Yes, what did you?
I used cars without permission, Your Honor. So,
what kinds of cars?
I used someone's car without their permission. So, to order a DoorDash, which was $40, and I was wrong, Your Honor.
All right, so in the back in using these cards, the value of the property that you received, was that in excess of $200?
No, Your Honor. It was.
The higher charge for the court. You didn't have anybody's permission to be using these cards.
Click, man.
All right. All right. Counsel, have I complied with you?
Since he's satisfied.
Court will accept and plead guilty to count 3, counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered for 14A2 probation. Sentencing in this matter will be May 28, 2025, 10 a.m. before Judge Clark.
Now I may address the issue.
Go ahead. Everybody else.
Your Honor, my client has originally was not incarcerated. John Court, I believe he was court. I think he had taken a family trip.
What?
He had taken a family trip. He was able to do that, but he wasn't able to make it in the next court. I believe that's how the case went. So, as a result, the court, we're asking that now that he's mentioned this is the property of my client is scheduled to start his classes on May 19th. We ask that he's bond will be that he be allowed to be released from the incarceration at this time.
So is he going to be at the EMU?
Community college.
Okay, so how do I know that he's going to get back here?
Oh, he'll make it back.
Huh?
He'll make it back. He's not enjoyed his time in Washington County Jail.
Okay, so how did he come into custody? You turned yourself in where? Here?
Yeah.
He knows how to make it back here.
Any response from the people?
That line right there, super-duper cocaine, says it all. Judges use humor like this to mask frustration. Beneath the sarcasm, total disbelief. But here's the legal kicker. When the judge orders levels to be checked,
Got it. That's what I know. Do you know the importance of showing up now?
Yes, Your Honor.
Have you ever been in jail before?
No, Your Honor.
This has been Mr. Brown's right. This has been an experience for you.
Yes, Your Honor.
And you take it serious, right?
Absolutely, Your Honor.
I'll reduce defendant's bond offset at $25,000 personal account for 6 months. Hey. Okay. There's complications of people versus Brendan Williams.
Ready to sit. Deputy Chief Public Defender appearing written on behalf of Mr. Williams.
Your name, sir?
Brendan Williams.
What are we doing?
Your Honor, we are respectfully requesting to, we're going to set this matter for preliminary examination.
So
My client is currently, yes, well, there's a complication. There's a new case that's arisen. We'd like to be able to resolve these matters, but we have to know what's happening in the new case. Part of this. So it is complete for this case. We may even resolve this shorter preliminary examination, but we will need to have that case.
the other case, does it affect this case?
Your Honor, Williams has a highly case set for ranking 2001, and the ranking set for the summer June 18th. Our request is going to be that for our Netflix state of that how people so that you can rank on this the job. We don't have one outside the one that I had several in this round. So if we're saying it's a thing, you know, we're in that time.
We go ahead and witnesses available on the 27th. Preliminary examination in for May 27th, 2024. 9 a.m. before Judge Fresh-Hour. And we'll continue. Thank you.
Anyway, we adjust the shit on.
I have a 10,000 cash.
Interesting that court consider in this case the person the cognitive found with the tether does have strong family support. And she's been in the court all day today and waiting for this matter. I've spoken with his aunt. She would be willing to allow him to stay with her. Couldn't see it.
The case, the new IBAC, what was the offense date of that?
Well, the IBAC posted you
Here's my problem. I've got that charge coming up, and I'm not presuming he's guilty, but I've certainly got a high level of alcohol involved in that. That case is coming up. I've got the indication that there's alcohol involved in this case, plus then assaultive behavior on there's at least alleged things. At this time, and maybe certainly after the fresh hour using her mind will change on this, but at this time I'm not just from this bond. I'm going to deny the request for modification of bond. Thank you. Court recalls case over Scott James.
And Stephanie Can on behalf of Mr. Jinks, who is appearing to my right. Mr. Jinks, please state your name for the record.
Scott C. Jenks.
Did you get it? Your Honor, I've spoken to my client regarding the possibility of a self-defense argument and his desire to potentially go to trial. My client has indicated he does not want to go to trial. He is not exerting a self-defense. He would like to proceed with the plea.
So you're waiving your right to assert a self-defense claim. Is that correct, sir?
Yes, sir.
All right. So at some point during the altercation with your wife, you, without her permission, put your hands on her and pushed her back. Is that correct?
Yes, sir.
All right. Counsel, with that testimony, has the court complied with the court will and would it be proper to accept the defendant's?
Yes, sir.
You have, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be June 5th, 2025, 10 a.m. before judge.
Your Honor, may I address bond?
Okay.
Thank you. Your Honor, with this plea agreement and the felonies now being gone, I would ask my client be released on a PR bond. Part of this was treatment. He could be screened for any sort of treatment necessary. He has strong family support. His daughter is here. His daughter is here. The family home has been vacated. It's my understanding from her that the complaining witness in this case is now living with the daughter and no longer at the family home, so he can go home.
His daughter?
Yes.
Okay. So, okay, good.
Yes. That the complaining witness is no longer living at the family home, so he would have somewhere to go. This is his very first time doing, well, anything. My client will appear for court. He has no desire, nor will he be seeking any contact with the complaining witness in this case, Your Honor. We're asking for a PR bond.
He is not under a confirmation that she has basically that because she has. However, I would leave in the expression as true. If he was to be released, Your Honor, I would ask that he place on a GPS tether as well as some type of testing, or alcohol testing or scan testing.
Do I have an indication of alcohol use in these cases?
Yes, Your Honor.
There's, okay. Well, I won't put him on a GPS because we can track him from scary junk, quite frankly, but what I'll do is I'll modify his bond. I'll give him $25,000 personal practices bond, so I'll release him, but he has to be placed on a scram tether prior to being released.
Thank you, Your Honor.
Thank you. All right. Thank you, sir. Calls the case, People versus Martinez Dalton.
Rachel, you're the people.
I'm Maggie on behalf of Mr. Dalton, who is appearing to my right, Your Honor.
Your name?
Martinez Dalton, sir.
I told you he was on the bus. I told you to get here, Miss Maggie. They didn't have any faith. I had all the faith in the world you were going to get me.
And I want to thank you for passing on the matter, allowing me time to get here, sir, in the time matter.
You know what? I had to, because she was just screwing it.
So, sir, I don't make no
Miss
excuses.
Duff wanted a bench warrant. I had faith in you, and so we didn't.
Thank you, Your Honor. Thank you, Your Honor. I appreciate that. I was coming.
Well, you know you.
Thank you.
I appreciate you going through the investigation. So,
Your Honor.
all right. And you're requesting an adjournment?
No, Your Honor.
Grant the adjournment. What are we trying to do on this thing? Oh.
All right.
So, Probable Cause Conference, May 29th, 2025.
All right.
Thank you, Your Honor.
Yes, sir. Thank you, Your Honor, once again.
Thank you.
Injury and drug. Now, this is where human drama meets the law. Romeo's lawyer paints a picture of a hardworking dad, student, and caretaker, pleading for mercy through context.